As everyone in Alberta knows, the Alberta Teachers Association has gone out on strike. 51,000 teachers are basically walking the picket line. Schools around the province are shut down. Alberta Premier Danielle Smith has threatened to bring in back to work legislation, maybe even invoking the Notwithstanding Clause in the Constitution so that her legislation would be protected against a constitutional challenge. So I'm going to talk to Professor Shaun Fluker from the Faculty of Law at the University of Calgary about why that's important. So welcome to the interview, Shaun.
Thanks for having me, Mark.
Okay, so my understanding is that other governments are using Section 33 of the Constitution, the Constitution or the Charter of Rights and Freedoms, to exempt their governments from the charter rights.
Yeah, Canada's Constitution, which includes the Charter, has a provision in it that allows legislatures, provincial or federal, to enact a power essentially to immunize their legislation from what would otherwise be charter scrutiny.
Okay.
That section, yeah.
Gotcha. And what's the implication of that? So, like, if you passed a piece of legislation and it had a charter challenge, it would go before a court, and then it could be challenged, maybe struck down, correct?
Yeah, so in the normal course, there might be a piece of legislation that is challenged under the charter as unduly restricting somebody's protected freedoms, whatever they might be. And the court would go through its analysis and conclude, well, look, this does constrain that liberty. It's not justified in a free and democratic society. Therefore, the court has the power under the Constitution to strike that piece of legislation down, whether that's a full act or just a provision of it or what have you. And Section 33 prevents a court from doing that. So in other words, it allows a piece of legislation that explicitly does constrain, restrict, remove a protected liberty. It prevents the courts from striking that as unconstitutional.
How does the Charter of Rights and Freedoms apply to unions and strikes?
Well, so generally speaking, and it's not really my area of expertise, so take this for that. But generally speaking, the right to bargain is a charter protected right in Canada under the freedom of association, I believe. Yeah.
Okay. So if she were to invoke the Notwithstanding Clause, then that would get around any objection to the back to work legislation on charter grounds. Why is this dangerous in particular? I mean, I've seen people on social media flagging it. They're lighting their hair on fire over this. I've seen some lawyers raising serious concerns. What's your take on that?
Yeah, so I mean, my approach to this is I teach a course at law school currently. It's called Law and Democracy, and really the course is all about using legal process to try to protect democratic institutions. And so I think the concern with the use of Section 33, and we're seeing it increasingly being threatened or actually used across various provinces in Canada. The concern is that this sort of use of Section 33 is anti-democratic in the sense that you have governments that are legislating against or at or attacking minorities and vulnerable groups, and they're doing so without evidence, or it's not evidence-based legislation, if you like. And they're using Section 33 in an attempt to shield that legislation from charter scrutiny. And so I think the main concern is that, certainly from my perspective, is that the use of Section 33 is undemocratic in the sense that it's currently being used.
Now, I remember, over the decades, really, every once in a while a story will come up and somebody will be accused of doing something undemocratic. It might be a premier, it might be a politician, who knows. But in the age of Trump, this takes on an entirely different flavor, doesn't it? Because Trump, as has been argued in interviews that I've done with American legal scholars, is essentially attacking the democratic institutions of the government, the constitutional distribution of powers, the machinery of government that upholds democratic institutions. And they say it's an all-out assault. And so this kind of has that flavor from, if you look at it through that lens.
It does. And, organized labor is, we could call that a democratic institution. And so, to the extent we have governments in Canada, the Smith government in particular at the moment, threatening to use Section 33 to essentially attack organized labor. The Alberta Teachers Association is certainly one of the largest unions in Alberta. I think it's quite reasonable to view that as an attack on a democratic institution.
What are the political risks for Smith's government? Because it's kind of surprising, actually, the amount of political support, public support for the strike. You would think with 51,000 teachers out on strike that parents would be just outraged. And in fact, the recent Angus Reid poll showed that the teachers have 58% support amongst the public versus 21% who support the government's position. And so given that circumstance, is there a potential for political backlash if Smith were to invoke the charter to support a back-to-work legislation?
Yeah, I think that one of the other interesting things about that poll that you mentioned, Markham, is that even within supporters of the UCP party, there's a healthy number of people who support the teachers. And so I think the risk that her government is taking is that this will be seen as contrary to our basic understanding of governance in this country, and as such that we don't really accept governments explicitly stepping on charter protected rights and freedoms, and that's what this looks like.
Okay, there hasn't been, even though she's threatened to invoke the Notwithstanding Clause for other issues like transgender issues, she hasn't done so yet with the strike, at least not that I'm aware of. So let me play devil's advocate here for a moment, Shaun, and say, she has said, we have more tools than just negotiation. You need to come and negotiate seriously. She's maybe holding the threat of a Notwithstanding Clause support for back-to-work legislation as over the teachers if they don't be a little more flexible at the bargaining table, which would mean this is a bargaining tactic as opposed to a serious constitutional issue. And how would you respond to that argument?
Well, I guess I look at the dispute between the teachers and the government a little more broadly and much more through a democratic lens. And so I don't think you can look at the current dispute in isolation from a number of other decisions that have been made by the UCP government over the last 5 or 6 years, which have really attacked public education, whether that's the curriculum or the refusal to address concerns in the classroom, restricting funding. To go back to one of your earlier questions, one of the risks that her government is taking here is that issues like, or questions like, the amount of public money that the Alberta government gives to private schools is now becoming a talking point in public dialogue. And so these are all, in my view, questions of worthy of democratic discussion. And so the strike itself and the impasse that we appear to be in is really just giving oxygen, I think, to these larger questions. And really the question of, where does this government stand on public education, very much a democratic institution, is quickly rising to the forefront in this conversation.
Right, because and I meant to at the beginning of the interview and I forgot, but I'll do it now. I should declare my conflict of interest because my daughter is a teacher in Calgary and works for the Calgary Board of Education. She's on strike. My son-in-law is an employee of the CBE, and so that puts me, I have a conflict. I should declare it, so I consider it declared. Given that, I've heard, amongst teachers, including my daughter, the concern about classroom size. Classroom size, sizes now can be 35, 40. Resources, for example, teachers don't have enough resources in the classroom to do their job properly. Overcrowding in the schools was another one, was raised during an interview with Jenny Jeremy, who was leading a recall campaign against the Minister of Education in his riding. So if I understand you correctly, you're arguing that the teacher strike has really become a flashpoint for some of these other broader issues that have been bubbling in the background for years and years.
Yeah, absolutely. It is 100% is. Yeah.
So from a legal point of view and a constitutional point of view, what happens next? Does she have to bring in back to work legislation and invoke the notwithstanding clause to really trigger the concerns that you've been talking about here?
Yeah. So one extra point about this that we haven't touched on yet is, if the Alberta government brings back to work legislation to the Ledge when it resumes its session at the end of this month, and includes in that legislation, invoking the Section 33 notwithstanding clause, then the Alberta government will be alongside what the Saskatchewan government did a couple of years ago, which is to say, preemptorily tell the courts butt out, right? So, I mean, historically and traditionally, the Section 33 power was intended to be used by a government after the court has ruled that the legislation is unconstitutional. And so it would give the legislature the ability to respond to that, and the thinking was that would be an extraordinary event. That would be a political calculation, and it would be used very infrequently. And that has been the case, more or less up until 5 to 10 years ago. We started to see more of it. But the real difficulty with it currently, and as the Smith government is likely to do if they're planning to go down this path, is it gets invoked before the courts have even weighed in. And so that dispute, or that question, that issue, is now what the Supreme Court of Canada is going to deal with here soon, because the Saskatchewan government attempted to do that in relation to that pronouns in school legislation that has proceeded far past where Alberta's at. And the issue there is, can the courts weigh in on the constitutionality of legislation, even in the face of the Section 33 clause? So obviously they can't strike it if they find it unconstitutional, because that clause prevents them from doing that. But the court in Saskatchewan, the Saskatchewan Court of Appeal, recently ruled, well, we can still say something about the constitutionality. We can declare it, for example, to be unconstitutional, even though we would be prevented from actually striking it because of Section 33. And the court's rationale there is very much democratic. The court is saying it is important for democratic dialogue for the public to understand what the constitutionality of this legislation is. And of course, governments like Smith's government and the Moe government in Saskatchewan, they don't like that, right? They don't like to be told that their legislation is unconstitutional. So, that's, I mean,
and that can trigger the notwithstanding clause application then? Is that the argument?
Well, I mean, they don't want the courts weighing in on their legislation at all when they invoke that clause. So they don't want the court saying, look, what you're doing is unconstitutional. You are trampling on protected rights and freedoms of your own citizens. They do not like that message, right? But that's exactly what the court in Saskatchewan is saying it's entitled to do. Even if you do invoke the Section 33 provision, we can still issue a ruling that says this legislation is unconstitutional. We can't strike it, but we can talk about it.
And speaking of that, sort of democratic discourse around these kinds of issues, some legal scholars have made the point that the real solution here is not the court's interpretation of whether things are, legislation is constitutional or unconstitutional. That's a poor place to decide this. In fact, they've argued for greater political participation by citizens. Citizens, I think it's fair to say, over the last 10, 20 years have become fairly disengaged from politics in many ways. And the argument then would be that they should get re-engaged and either elect governments that will respect the notwithstanding clause or whatever. But this strike seems to be the very essence of democratic action, and would be what those scholars were arguing for. Have I got that argument correct?
Yeah, I mean that position that those scholars take and others is that the judiciary is unelected, it's not accountable to the electorate. It shouldn't be weighing in on on these types of issues, which they deem to be highly policy laden or what have you. Um, what they don't talk about is that a lot, legislatures in a lot of jurisdictions nowadays, I mean, there's a lot of broken democratic mechanisms within them as well. I mean, you may have read Andrew Coyne's recent book that he published this year, and it's a scathing critique at the federal level of really all of the democratic mechanism and institutions within Parliament, or if we're talking provincially, within legislatures. I mean, to the point where you have to ask yourself, how democratic is the elected House nowadays? So, the argument that the courts are somehow illegitimate here because they're unelected, to me, frankly, just carries no water. And the last point I'll say about that is, again, a lot of the concern with this type of legislation is that it's not based on evidence. And so the judicial process very much forces governments to bring forward the evidence. And you may know or recall, or some of your listeners may recall, that in Ontario, the Ontario courts recently told the Ford government, no, you can't legislate away bike lanes because the evidence that you've put before the court all shows that they enhance safety. And so, no, come back. You're welcome to legislate on this topic, but it's got to be evidence-based. So I just frankly think that those arguments that the courts aren't legitimate, they just don't carry any water for me.
Well, Shaun, thank you very much for this. The strike isn't settled yet. I guess we've got another week or 10 days before the premier has promised to act, if she's going to. So we'll monitor this and maybe have you back after we see how she is going to act. So thank you very much for this.
You're welcome, Markham.